There's something which is often read at funerals, and you'll notice that in this specific episode, we're going to have a bit of a focus on death because, in law, prescription in a sense is a bit like death of a legal matter. So, I'm going to look a bit at memento mori, the Latin phrase, and a bit at something which appears in, I'm reading from Ecclesiastes, chapter 3, verses 1 to 8 in the New International Version translation of it. And it's something that you probably have heard at a funeral. It says, "There's a time for everything, a season for every activity under the heavens, a time to be born and a time to die, a time to plant and a time to uproot, a time to kill and a time to heal, a time to tear down and a time to build, a time to weep and a time to laugh, a time to mourn and a time to dance, a time to scatter stones and a time to gather them, a time to embrace and a time to refrain from embracing, a time to search and a time to give up, a time to keep and a time to throw away, a time to tear and a time to mend, a time to be silent and a time to speak, a time to love and a time to hate, a time for war and a time for peace." Now, moving on to that, on from that, there's the old story that in ancient Rome, when a general would return home from battle, he would have his slave state to him memento mori, which means remember that remember your death, your mortality, that you too will die, or that you will die one day. I actually follow an account on Twitter which tweets nothing out except for um, you will die one day or something like that, and it's an interesting thing. It's an interesting reminder. And then, of course, I think they also say something like respice post te hominem te momento. And it's a reminder that the person is only human and mortal, and to remember that rather than to give into their hubris. So let's start looking into prescription. Now, you might have been taught about prescription in law school and been taught 3 years, that's the rule and that's all there is to it. Well, in that case, you might get into a bit of trouble because in certain matters, prescription is much earlier. It's not prescription in the classical sense, but for instance, if you do an antenuptial contract, within 3 months of signature, it must be registered. And quite often there's a error in the office or something happens, doesn't get registered, couple has since married, and the antenuptial contract is therefore not valid against third parties, and the parties need to go through an expensive court process to get the marital regime that they want. So let's go on to prescription. Now, it's important to state prescription and other time periods that must be adhered to in a matter, state when these occur and what measures are being taken to ensure the matter does not prescribe or become unvital and baseless. And if you speak to the attorney's uh, indemnity fund, the one which pays out when attorneys are being negligent, they will tell you that the number one or the major sort of thing which causes them to have to pay out is prescription. There's an error in an office and something prescribes. It's not the fact that the attorney doesn't know the law properly, it's the fact that the matter prescribes. Okay, so once we've noted these things, these times in which we need to be aware of things, we also need to note the strategies to make sure the matter does not become unfunded at a vital interval. You might think, well, that's not really prescription, that's something else. But quite often, an attorney will find themselves in a position where they need to bring a matter to trial, they need to get an advocate involved, and the client says, well, I don't have funds. So you put the advocate on the matter, and so the attorney does. Except that the client then doesn't pay either attorney or advocate at the end of the day, and the attorney becomes liable for the advocate's fees, and it can be quite catastrophic. That's not saying that that's always the case, but attorneys who don't pay advocates get put onto the list of defaulting firms, and in some areas, the attorney actually has to pay the advocate, depending on the different High Court decisions. So it's quite important to not only be aware of the time periods you have to adhere to, but to make sure that you have the funding in order to act in the way that you need to, or to remove yourself from the matter if you don't. And then, if unknown, state the dates of major events relevant to the matter. So just get a record of things so that you can work with them later. Okay, so prescriptions and ways of determining it. For this, I've relied heavily on Ambler's 8th edition on page 314. And I understand Ambler's has gone to 9th edition, and I have 9th edition, but when I created this list of legal considerations for myself to consider, Ambler's was still on its 8th edition. So I'm going to quote from Ambler's quite a bit here and then talk about things. So the effect of prescription is the first thing you're looking at. And Ambler says a debt is extinguished by prescription after the lapse of the prescriptive period applicable to that debt. This means inter alia that the debt cannot be revived, not even by an acknowledgement of liability, unless the acknowledgement amounts to a new undertaking. Then you have another quote from them, which is a prescribed debt cannot be set off against any claim, but the payment of a prescribed debt is valid payment and cannot be reclaimed. That's interesting. That's a nuance which is quite important to do with prescription, because paying a debt which is prescribed is not paying something which is an unjustified enrichment of the person you're paying. It's valid. And so if you make the payment, you made the payment. And the cases go into a bit more detail with that. Now, on the subject of prescription as death, what's life, one might ask? And the distinction between life and that which isn't life seems to be that life orders itself and the things around it. Right from conception, human beings do this, and other animals also tend to order themselves. And bacteria will also do that. They order themselves. The specific DNA in one cell in one area works differently from the DNA in another area of the body. So life seems to order itself, while that which isn't alive tends to descend into chaos over time. And it seems to be the natural course of the universe to go from higher energy to lower energy. Life, in contrast, seems to order itself and to increase the energy inside of it until such time as it starts declining and eventually dies. So I like to think of prescription as, until prescriptions run out, there's still a chance to order things around, to use the law to bring order to a matter and to bring resolution. Once prescription has run, there's certain nuances you can use, but by and large, you've lost your opportunity to order things, to make the matter come to a resolution, to an order. Instead, it will often descend into chaos and be lost. So, next we look at the debt. Now, to quote Ambler's again, the debt. Prescription extinguishes a debt. Although the term debt is not defined in the Act, it refers to anything that is owed or due, such as money, goods or services. A debtor is under an obligation to pay or render to a creditor. Same page again. Okay, and then it goes further. The word debt generally refers to the claim and not the cause of action. Now that's quite important. And the question isn't when something happened, but when something was due as a result of what happened. Okay, so to quote more from them, it includes a debt owed to the state as well as debts of statutory origin. They go on further. A claim for rectification of a contract is not a claim for a debt and does not prescribe. Now that's interesting because we're talking about cause of action versus debt. A re vindicatio is also not a claim based on a debt. They say re vindicatio means I own something, give it back to me. So this is not a claim based on debt. Now that's interesting, though you need to also be aware of something else which I'm not covering here, which is acquisitive prescription, where if you possess a home for a certain amount of years and you do so peacefully, you can actually acquire ownership of it. That's the idea from, I think it's in the Act, and it's possibly also coming from earlier law as well. So res vindicatio isn't extinguished by that, but you might run into problems of acquisitive prescription. Okay, so for a spoliation order, claims made over a year after the spoliation occurring needs to show special circumstances. There's some interesting case law there, and if you can show reasons for the delay in trying to get the property back, then you might still succeed. Spoliation essentially is mandament van spoli. It says that, and it comes from the fact that the Romans um, did not like people acting outside of the law. If you were going to take something, it had to be lawful, not through force, even though the Romans were incredibly powerful with their use of force in a military machine. So, spoliation says if you are in peaceful possession of something and someone takes that possession away from you, that's something which they should not be allowed to do. And so the law will protect the person who's being spoliated with a interdict known as Mandament van Spurley. And when I was studying at the University of the Witwatersrand, I understand that one of my lecturers in their legal practice, which was a public interest type of thing, would actually use spoliation as a criminal form of spoliation to um, prevent spoliation. So apparently there's also a criminal element of it that you can report spoliation to the police, which was quite interesting. Okay, so when was the debt due? When was it immediately claimable by a creditor in legal proceedings with the debtor obligated to perform? And is there a continual wrong? When did the creditor have knowledge of the identity of the debtor and facts causing the debt? So that's also another important question to be asking. So ordinary prescription is 3 years. Exceptions, now I'm going to quote from Amler's again. Debts secured by mortgage bond, judgment debts, debts in respect of taxation or levies, and debts owed to the state in respect of any share of profits in respect of the right to mine minerals or other substances, 30 years. Okay, certain other debts owed to the state, and again, and it says 15 years, and again, this is Ambler's 8th edition, page 314. Then debts arising from a negotiable instrument or notarial contract, 6 years. That's Ambler's 8th edition, page 314. A claim for a contribution in terms of the Apportionment of Damages Act, 34 of 1956. This is important. Okay, so they say 12 months calculated from the date of the judgment in respect of which a contribution is claimed. So that actually gives you a good option to sort of push things forward after there's actually been a judgment, rather than trying to push apportionment of damages immediately. If you are to accept Ambler's approach there. Okay, delays. So, to quote Ambler's page 314 again, completion is delayed while, for instance, the creditor is a minor, that's someone under the age of 18 or someone without mental capacity possibly. The debtor is outside the Republic. The debt is the object of a dispute, subjected to arbitration, or when the debt is the object of a claim filed against the estate of a debtor who is deceased, insolvent, or in liquidation. If one of these circumstances is present, the period of prescription will not be completed before a year has elapsed after the day on which the impediment ceased to exist. That's Ambler's again. So then Ambler's deals with interruptions, which again I took important parts out of them, out of their presentation on it, without taking all of the flesh and bone out of it. So this is really skeletal, and if you have a matter, you should actually look at the cases they list there. Okay, so interruptions, an express or tacit acknowledgement of liability by the debtor or his or her agent. That's something which can really continuously push back prescription, and often creditors try and do that. Then it says service on the debt of any process whereby the creditor claims payment of the debt. That's more complex than what they say there, so make sure you actually look at the case law there. Then it is, and I've got ... not interrupted by process issued by the wrong creditor. And then notice of joinder is usually not a process whereby a creditor claims payment of a debt, therefore does not interrupt prescription. And then, although the running of prescription is not deemed to have been interrupted if the creditor does not prosecute the claim successfully under the process in question to final judgment, no time limit is stated within which the claim must be prosecuted successfully. So then they go on to prescription against surety. If the principal debt is kept alive by a judgment, the surety's accessory obligation continues to exist, in that the obligation of the principal debtor and the surety relate to the same debt. So you're seeing it's the actual debt which is the important thing and which is being extinguished or not. Okay, interruption of prescription of the principal debt also interrupts prescription of an accessory debt, i.e. that of the surety. So it's the debt which is the thing which is being kept alive and being dealt with, and therefore the matter is being kept alive. Prescription against the state, the prescription period of 15 years in favor of the state does not apply to state organs, but to juristic persons capable of suing in their own name. So it does not apply to state organs, but to juristic persons capable of suing in their own name for what is due to the National Treasury. This is page 315 of AMLA's. And we move from page 314 to 15 when we started with interruptions a little bit back. Okay. Waiver of prescription. The right to rely on prescription can be waived. And there's an interesting case with that where it went to court. So be sure to actually look at what AMLA's has there. Follow the case, read it. It's absolutely fascinating, and it has a result which can be quite shocking if you are too wired into the idea of prescription ending the matter after 3 years, no matter what, that they often will push into you at law school. Amendments of pleading. In amending a pleading, the question often arises, AMLA says, whether the amendment introduces another cause of action that has prescribed. If it does, the amendment may be refused. Since the plaintiff may have an answer to the plea, we're going on to page 316, to the plea of prescription. It is under special circumstances only that an amendment may be refused on this ground. Okay, notice states of proceedings against state organs. Now, I'm not sure if I base this on AMLA's or on the Act itself. Nonetheless, an organ of state is any national or provincial department, a municipality contemplated in Section 151 of the Constitution, any functionary or institution exercising power or performing a function in terms of the Constitution or a provincial constitution referred to in Section 142 of the Constitution, the South African Maritime Safety Authority, the South African National Roads Agency Limited, National Ports Authority Limited, or any person for whose debt an organ of state is liable. Okay, notice and condonation for late notice. So you have to give a very specific notice to organs of state, and I'm not sure where I've got this from. I think I got it from the Act itself, but it might be from AMLA's. So a notice must, within 6 months from the date on which the debt became due, be served on the organ of state in accordance with Section 4.1, and briefly set out the facts giving rise to the debt and such particulars of such debt as are within the knowledge of the creditor. And then finally, the last bit on our prescription section, which is where we're dealing with this organ of state which you are suing. If an organ of state relies on a creditor's failure to serve a notice as prescribed, the creditor may apply to a court having jurisdiction for condonation of such failure. The court may grant an application referred to in paragraph A if it is satisfied that the debt has not been extinguished by prescription, good cause exists for the failure by the creditor, and the organ of state was not unreasonably prejudiced by the failure. If an application is granted in terms of paragraph B, the court may grant the leave to institute the legal proceedings in question on such conditions regarding notice to the organ of state as the court may deem appropriate. And while the section on prescription has been relatively short, I think that it's quite important to realize that one of the main things that can destroy an attorney's career, or which can cause them to negligently harm a client's matter, is prescription. And it's so often the case that there's just a mistake in the office, the paralegal misplaces something, something goes wrong, and because of an office mistake, a lot is lost. And where there are default judgments where there shouldn't be a default judgment, where a firm has proceeding when they shouldn't, and then they have to reverse a judgment, when there's all kinds of things which happen in law, 90% of the time when something goes very wrong, that is specifically because of an office error. And that's one of the most essential things which an attorney or legal practitioner of any form needs to guard against. You need to have a good filing system. You need to have a good system for booking what date you need to do something specific on. And having that type of system and diarizing things properly and knowing where things are at all times and knowing where your matters are and knowing which matters you shouldn't take because you might mess them up because of the time frame is so incredibly important. And something else which is important is that while a debt might die and the matter with it, it shouldn't be something which is taking down an attorney's firm. There should be a way to make sure that prescription doesn't catch you. And prescription ultimately will catch any matter which isn't proceeded on in good enough time. So I cannot emphasize enough how important it is to deal with prescription properly. Thank you very much for listening. My name is Marc Evan Aupiais. Nothing in this presentation constitutes legal advice, and nothing in this presentation should be relied upon as legal advice. For that, please approach your own attorney and inform them of all of the nuances of your matter and allow them to deal with your matter properly. Thank you very much.